Good day, ladies and gentlemen, and welcome to the German Competition Law Update conference call. I would like to introduce Stephanie Biermans, Axel Gulmuth, and Annette Schild. Ms. Schild, please proceed.
Thank you very much, operator. And good afternoon, ladies and gentlemen, and welcome to the Arnold Porter Update Seminar on German competition law during the last 6 months. I'm here with two of my senior colleagues from the German competition team here in Brussels, Stephanie Biermans and Axel Gulmuth, and we hope we'll have some interesting things to tell you today. Before we get to that though, I do have just a few housekeeping matters to tell you about. One is if you'd like to see us a little bit bigger and also not see the black box on the screen, you can do that. You can move around the picture wherever you want on the screen, and you can minimize the black box that you see on the right side, I think, of the picture. Second one, we really welcome questions, so please don't hesitate. The way to do that is to click on the tab at the top of your screen, which will show you a chat function, and you can type in your questions at any time. We have somebody here to take notes and hand them over to us, and we'll try to answer them right away. If that doesn't work, we'll get back to you later. Then the last housekeeping is, yes, you can get CLE credit for this. I am not 100% sure how it works. I think you will have to tell us that you need the credit, and then we will have to send you a few really difficult questions that you would need to answer to show that you really listen to this, and then you'll get the credit. I really don't think it should be an issue. So I guess, yeah.
And Annette, you rightly said good afternoon. I think we can also add good morning and good evening, because we again have a great audience for this webinar from all over the world. We have participants on the line from the US, from Europe, and from Asia. So to everyone, it's a great pleasure for us to be able to speak to you today for the next hour.
Welcome. So here's our agenda for today. Annette will kick it off with a short report on interesting merger decisions over the last 6 months. Then I will tell you a little bit about cartel enforcement and fines, followed by Axel, who will shed some light on private enforcement activities in Germany, and also what's in the legislative pipeline regarding private enforcement. Then I believe Annette will scare us a little bit in the cartel enforcement part when we learn about the new or broader interpretation of illicit information exchange. Somewhat less scary are the recent amendments to the German Competition Act, which entered into force this month, and the outlook on major pending cases with which Axel will conclude this session.
Thank you, Stephanie. Mergers. Well, there's a long list of topics. It probably looks a bit scary, but I think it's actually quite interesting what's happened over the last 6 months. Not necessarily because there was anything revolutionary, but because each of the cases that we're looking at really helped shed light on some of the concepts of German competition law, and how to go about notifying mergers and looking at various elements of the analysis. So I think it's actually a quite interesting half year in that respect. First one, let's look at that. Domestic turnover. That's obviously a very important question. On the one hand, whether you actually get over the thresholds, because you do need to have a certain turnover in Germany, as you all know, or whether you come into the de minimis sphere. It is always a question how you attribute turnover. And you may have followed this before. There was, a while ago, there was a decision by the Federal Cartel Office that looked at how you attribute turnover in a situation where the contract is made outside of Germany. It's a multinational company. In this case, it was in Switzerland, that central purchasing decisions, concluded a contract centrally, but then had the goods delivered in various countries, including in Germany. Federal Cartel Office said, well, the specific performance of the contract is the delivery. That is in Germany, so clearly we look at the German turnover. And that is what was now confirmed by the higher regional court in Düsseldorf. What I find interesting, because we have the question not only in Germany but also in the EU, the Federal Cartel Office is 100% convinced that this is fully in line with what the EU is doing in the jurisdictional notice. And if you look at part of the notice, I think they're entirely right, because they also talk about the place where the specific performance takes place. On the other hand, there's also something about multinationals, and I'm not 100% sure that the EU would come always to the same conclusion as the Federal Cartel Office. But that is there to see. The next decision is interesting. That is a clearance decision. And that's interesting, I thought, if you look at the concept of competitively significant influence. Because here we had a situation where the purchaser wanted to buy 10.1% in another company. And not only did the Federal Cartel Office say, yes, we have jurisdiction to review that, but they also found so many problems that the buyer had to give commitments to sell several hospitals in an area where the Federal Cartel Office thought they were dominant. Question is, of course, always, if I buy such a small stake, well, why do I really need to notify, or when do I really need to notify that, and when is there really an issue? In this particular case, the situation was quite specific because the articles of association of the target gave reasonably significant veto rights starting at 10%, and they're still fighting about that. And these veto rights correspond largely to what a 25% shareholder would have under the law, under the Stock Corporation Act in Germany. But we thought it would be interesting to look a little bit more at the issue of the competitively significant influence, because first of all, the EU is looking at introducing merger control for minority shareholdings, and they always say that Germany is a brilliant model. Of course, as an EU lawyer, you know that the German process is so much faster and more efficient than the EU process that you sort of think, well, please, not on the EU. Nevertheless, it is interesting. I think it is also interesting to look at some statistics, because while these cases in Germany that are notified under the rules of acquisition of competitively significant influence are really very few and far between, less than 1% of all notifications in Germany every year, they tend to be the more problematic ones. I think on average, you have less than 0.5% prohibitions, and you have more than 10% in the case of these, or interventions in the case of these cases. Now, what is a competitively significant influence? Actually, the Asklepios-Röhn case is the model case, the textbook case, because the general thing that's said covers the acquisition of an interest if the acquirer obtains rights that are equivalent to those of the shareholder in a German stock corporation above 25%. And those are, in the EU, those would usually be considered as minority shareholder protection rights. So they don't give control yet, but they can have an impact on the competitive behavior of the other company. Now, of course, that only applies if there is a horizontal or vertical relationship between the parties, so a financial investment of 10% and somebody who does something completely different would not be caught. What rights can lead to a competitively significant influence if we don't have sort of the matching of the Stock Corporation Act? Well, there's all sorts of plus factors that have been found to be relevant, such as the right to appoint members of the board, veto rights that are relevant for the company's competitive behavior, so expansions, sales of businesses, a particular industry knowledge if the other shareholders are not really that knowledgeable because they are financial investors perhaps. Important ongoing business relationships and a vertical relationship. So if the guy who buys 10% is a supplier or a customer, that might be relevant. They're really important. Call options and many more. But I've said the good news, there are still a lot of cases where you don't fall under German merger control. The lower the shareholding, the more rights you obviously need. Usually there's no intervention with below 10%, although that is not a clear rule. And also, as we found out recently in one of these cases, the Federal Cartel Office tends to care significantly less about acquisitions of low shareholdings in vertically related companies than horizontally related companies, which I think makes an awful lot of sense. Now the next, shall we say, buzzword is product market definition. And we have here this in the example of the ice cream merger, where you had two private label ice cream companies going together. Because I think they did a very beautiful and step-by-step analysis of what the relevant product market is, whether in particular private label ice cream is in the same market as branded ice cream. And they came to the conclusion that it is not. How did they come to that conclusion? Well, they saw that customers employ different sourcing strategies, that suppliers tend to produce one but not the other, that there are significant price differences in the end, and then also apparently they found quite a number of documents at the companies that demonstrate that they don't really see branded ice cream as a competitor. Merger fortunately was cleared nevertheless, because in spite of the fact that they had almost 50% market share, because switching turned out to be easy, because the recipes apparently don't belong to the producer but to the customer, so they can just shop around and see where they get the ice cream the cheapest. There's a lot of overcapacity in the industry, significant buyer power as we know, and there were no vertical foreclosure concerns.
And so, Annette, when I remember that when we did the last webinar back in January, we were discussing a case involving alcoholic beverages.
Oh yes, Aquavit.
Aquavit, exactly. Where the Federal Cartel Office also raised the question to if the private label brands were in the same market as the branded beverages. And at the time, the decision had not been published yet, so we couldn't really explain it to the audience back then, but I think it has come out now. So how would you compare the two cases on that aspect?
I think it's actually very nice to look at those two cases together, because they show how case-specific product market definition really is. I mean, there's absolutely no general rule. Private label and branded is in the same market, is not in the same market. It really depends on the product and the specifics in the area. And there, interestingly, they didn't even find that Aquavit is necessarily a market, irrespective of what branded or non-branded. Apparently, I'm not a drinker of Aquavit, but apparently there are all sorts of schnapps beverages that are made with similar ingredients that people would consider as substitutes. And also they looked at similar things, and apparently also from the supply side things aren't quite as strict, so people would make both private label and branded goods, and the price differences are not so big, but it's really nice to look at those two cases together, I think.
Interesting, yeah.
So next buzzword in this lovely coefficient decision is the German balancing clause. As you probably all know, that's reasonably specific to Germany, and it's a way for a merger to get approved, even though it may lead to the creation or strengthening of dominant position, which until recently was the test in Germany. And that is, it can be cleared if the benefits that arise in other markets outweigh the harm that is being done in the market where the dominant position is being created or strengthened. What's interesting about this is really, again, it's a textbook analysis. In particular, if you compare it to a previous case, which had the same at one of the same companies, namely Kabel Deutschland, because a few years ago they acquired some Orion subs, I think in 2008, and there you also had a creation or strengthening of dominant position, but the balancing clause came out in favor of the parties and the acquisition was approved. Here it was absolutely desperately necessary to come to the balancing clause because basically number one wanted to buy number three, and frankly there wasn't much, or there isn't that much, at least nobody big after those three. And the number three overlaps 3/4 with the number one, which means that on the one hand that many households simply wouldn't have any choice anymore, that today do have a choice, and also that the existing oligopoly between the two large ones would be further strengthened. Now, why did the various improvements that allegedly would result from the merger not found to be sufficient? I think the parties came up with 4, all of which basically said that more people would have access to, more households would have access to broadband and narrowband. Well, some of those were not really structured. Some of them were clearly not merger specific. One of the things raised by Tele Columbus was something that was available to households already, except that Tele Columbus didn't market it. They just reacted if somebody asked. Another one was that the two parties had been negotiating, but they hadn't come to an agreement yet, but they could just come to an agreement irrespective of the merger. And what that was then left over wasn't all that much, and so the Federal Cartel Office clearly decided that it was insufficient to balance the negative effects. Now, what is our buzzword? What is this interesting for? Other than for the Germans, who probably all feel strongly about those two being combined. Well, the failing company defense for the non-Germans, Frankfurter Rundschau, very important national paper, simply failed and was bought by the other Frankfurt paper, Frankfurter Allgemeine, which is also a national paper. The two of them come from the same region, so there was clearly an issue in that particular region. But the Federal Cartel Office found that the acquisition fulfills the requirements of the failing company defense. What may be an interesting takeaway is that the analysis of the Federal Cartel Office follows the EU analysis that was done originally in Carlingen-Salz. It's an very old case. But it does not correspond fully to what the EU has used more recently, which is the one in BASF, Euro-Pantoschin, where the EU did not specifically look whether all the market share that Frankfurter Rundschau has would automatically have accrued to Frankfurter Allgemeine. I think the EU test would also have led to the conclusion that there's a failing company and that this is sufficient to justify the merger, but it's still, it is a slightly different approach. So I think that's an interesting takeaway. Now this one is also interesting because I don't know whether it's the first case, but it certainly is one of the first cases where the company that wanted to sell some of its business to somebody else and was prohibited from doing that, or where the merger was simply prohibited, then wanted to sue Germany for 1.1 billion in lost profits and procedural costs on the basis of principles of public liability, Amtshaftung, as it's called in German. Now, there was an awful lot of speculation about this case because, of course, all the lawyers said, well, how on earth are you going to prove damages incurred, and is it really true? I mean, is the seller really the one who should be suing here? And causation and all of these things. Well, the Court of Appeals in Cologne found a very elegant solution to all of this. They didn't even get there because while they agreed that there was a breach of administrative duty, after all, in this particular case, the German Supreme Court had said that the FCO's decision was illegal, and so that basically this should have been approved, so it was clearly a breach of administrative duty. They said, well, under German law, you also need fault. So either intent or negligence. And since that wasn't there, they didn't have to go into any further questions on damages. I think this is quite instructive because I cannot see any case where it's going to be possible to prove fault on the case of the FCO.
Quite a relief for them.
Yes. So I think that certainly is an important case also. Well, and that one, here, this is a case where an individual was fined 90,000 euros, after all, for not fully disclosing all relevant information that is required in a notification. Obviously, as you know, the German notifications tend to be quite short, and people often make them even shorter than what is required in the law, and usually get away with it. But here, the information that was withheld was really important in the assessment of the case. And so the Federal Cartel Office just said, no, that's not okay, and did fine an individual.
And I can confirm that we recently had a case where one of the other parties to a merger also was not fully transparent on information which was arguably not that important for the assessment of the case, but still got into major trouble with the FCO. So I think that's something one should pay attention to.
Okay. So I think that's me for mergers. And I would like to... Oh, this is not working. Can somebody advance this? I was hoping to switch over to Stephanie, but somehow. Okay. And her fascinating topic of fines, scary topic of fines.
Can we go one further, please?
Let's see. Yes,
okay. Here it works. So a quick overview of the topics I will touch upon. The main topic is the first one, the new guidelines on the setting of fines, which is the hottest topic in that area for the time being. The new guidelines were published in June of this year, and they were made necessary after a decision of the German Federal Supreme Court. As you can see on the slide, German law says that a cartel fine must not exceed 10% of the global total turnover of the entire group of the offender in the business year preceding the fining decision. This rule was modeled on a similar provision in EU law, and the EU rule is, with the blessing of the EU courts, interpreted as a cap. So what the FCO did the same thing, because after all, Article 81.4 was introduced to harmonize German and EU law, so they also interpreted the 10% threshold as a cap. And now the Federal Supreme Court said, no, you can't do that. For those of you not familiar with the intrinsities of German law, you may wonder, what the hell is the difference between a cap and an upper limit? So let me explain. If you regard the 10% threshold as a cap, the entire calculation of the fine can take place above that threshold. So all the legal criteria that need to be taken into account for the calculation of the individual fine are calculated in a purely virtual calculation, and at the end the fine is capped at 10%, and that's it.
So the calculation could lead to 50% and...
Yeah, or 100 or 200, there's absolutely,
okay.
The sky is the limit.
Okay.
So this has two major drawbacks, because in particular for small undertakings which offer only one or very few products, you easily start the fine calculation above the 10% threshold. So that means that all the legal criteria that need to be taken into account, such as gravity of the infringement, duration, aggravating and mitigating circumstances, are of no consequence whatsoever for the final fine, which would be just 10%. And that happened quite a lot because, as you know, the German Mittelstand is quite strong, so there are quite some companies who fall into that category of only having very few products. The second major drawback of this approach is that you can't really differentiate if two small companies, one of them is the instigator and a real bad guy, and the other one, just sat there and listened and didn't really participate very actively, but nevertheless they were both members of the cartels, and they will walk out both with 10% fine. So they're both hit equally hard, even though one should think the bad guy should be punished a little bit more. This is for those of you who want to understand how the fine was calculated in more detail, but I don't want to spend time on that. But going back to the example I just made with the good guy and the bad guy, let's assume that company A is the good guy. They would get a reduction for mitigating circumstances, but tough luck, there's a reduction, but you won't feel it because the calculation of the reduction takes place somewhere up there. Same thing for the bad guy, for company X. They have to pay more for aggravating circumstances, but same thing, cap is capped at 10%, so they both walk away with the same fine. No. Okay. So the Supreme Court took issue with exactly these flaws of the old guidelines that I just mentioned, and it made very clear: no, the 10% threshold cannot be regarded as a cap, but it needs to be interpreted as an upper limit of the fine. It said under rule of law reasons, a law that provides for sanctions, even if they are not criminal in nature, needs also to provide a lower and, in particular, an upper limit for the sanction. That law also needs to provide the criteria that will be taken into account when determining the individual fine. And these criteria need to affect the final outcome somehow. And finally, the court said that the maximum, the upper limit, the 10%, is really only for the worst possible infringement. So it's a little bit like the capital punishment.
It also means that our arguments actually have a point, because we can do something about the fine.
Indeed, because now if you look at, so what does it mean, this interpretation as an upper limit? It means that the entire fine calculation takes place below the threshold. So now, if we argue about how long the infringement really was, or whether there were mitigating circumstances, this will have an immediate impact on the fine. And of course, that's much nicer.
It is more satisfying.
Much more satisfying. And of course, now you can also differentiate between the good guy and the bad guy, because you have room for maneuver. Well, the question arises, if the 10% are the fine for the worst imaginable cartel, let's assume that a large undertaking is involved in such a cartel. Will they now be faced with a fine in the range of 10% of the annual global turnover? That was certainly not what the Supreme Court had in mind, and the FCO introduced its guidelines an additional step to make sure that this will not happen. So for large companies, so companies with a large annual turnover, there will be a different upper limit. How is that calculated? The starting point is the so-called gain and damage potential that is set at 10% of the turnover achieved with the cartelized products over the time of the cartel. And this amount is then multiplied with a multiplying factor which is determined based on the global turnover of the undertaking. And the multipliers range from 2 for undertakings with a turnover below 100 million euro, up to 6 or more for the really huge ones with a turnover of 100 billion or more. So the result of this calculation will then, provided that it stays below the 10% threshold, be the formal upper limit for the fine calculation. If the multiplication takes us above the 10% threshold, then the 10% threshold remains the limit. So again, to make that a bit easier to understand, here we again have our company A, and we have a company B, which is quite a big one with 10 billion annual worldwide turnover. Let's assume they both participate in the same cartel. They have the same cartelized turnover. So the gain and damage potential is the same. The only variation is the multiplier, which is 3 for company A, 5 for company B. In the case of company A, the multiplication takes us above the 10% threshold. So the upper limit for the fine calculation is the 10% threshold, which is 10 million in this case. In the case of company B, the result of the multiplication stays below the 10% threshold, 25 million. So instead of finding the upper limit at the 10% threshold, which would be 1 billion, it will be 25 million, which sounds much more reasonable to my ears. So what will this mean in practice? The FCO has put all its settlement and fining decisions on hold after the Supreme Court judgment, and now, after it's published its new guidelines, is working on these cases and has indeed taken the first fining decision based on the new guidelines last week. From what we saw, the differences aren't that big in the currently pending cases. And I think the same will be true for the future. It will probably be the case that the smaller undertakings will stay well below the 10% threshold, because I don't think the FCO has much appetite to fight in court over what is the worst possible infringement. And on the other hand, fines for the larger undertakings probably go up a little bit, but even under the old guidelines, the FCO in practice tried to differentiate between smaller and larger companies. So that's it on fines. I quickly want to touch upon a judgment of the Federal Constitutional Court, who declared a rule as constitutional, which allows the FCO to impose interests on fining decisions which have been appealed, but where the appeal has been withdrawn. There was the possibility of abusing the appeal process in this context, so the rule was introduced to fight that, but one really needs to think about that when withdrawing an appeal for whatever reason, that there is a risk that the FCO will ask for fines going back to the date, to the fining decision, which can easily be a couple of years back. So that can be quite substantial. Two interesting fining decisions. The first one was made by the Higher Regional Court in Düsseldorf, and this reminds us that if you appeal a fining decision in Germany, you run the risk that you walk away with the result and you are worse off, because the decision of the authority will be replaced by the court decision, and it can go either way. It can be favorable for the appellant or to its detriment. And this was clearly the case here. The court found that the FCO hadn't correctly assessed the facts of the case, and it came out with fines that were up to 85% higher than in the FCO's fining decision. So
that's really quite different from EU, because there you always have this in the abstract, and there was a decision, there was a case where they actually went up that it was absolutely peanuts. No?
Right.
But
And
85%.
this is quite an extreme, but one has to bear in mind it is a possibility.
Oh.
And the last decision I want to mention goes back to our first point, because in the floor mill cartel, the FCO was struggling with the fact that all the participants in the cartel were relatively small one-product companies. They all made floor. So most of them would have ended up at the 10% threshold, and the FCO didn't have the possibility to really differentiate between the individual offenders. So what the FCO did was to lower all the fines in order to win some room for differentiation. And that is pretty much what the EU Commission did last year in the window mountings decision. So I think that it also comes to the authorities' attention that something may be wrong with the capping rule. Finally, the FCO took inability to pay arguments into account, because the offenders here had been involved in similar cartels in France and the Netherlands, and the FCO concluded that at least some of them wouldn't be able to pay all the fines together. Okay.
Interesting.
So with that, over to you, Axel.
And to private enforcement. Thank you very much, Stephanie.
Scary thing after scary thing.
Yes, indeed, because private enforcement, as you all know, has become the second reason, in addition to the fines imposed by the Federal Cartel Office or the government, why it has become so costly for companies now to be involved in illegal cartels. And in Germany in particular, it's now very frequently the case that victims of cartels will sue the cartel members for damages in private court. And there is an example that has occurred in the last 6 months, which is noteworthy, where a member of the German rail track cartel, a company called voestalpine, reached an out-of-court settlement with the main customer of rail tracks in Germany, so the main cartel victim, which is the Deutsche Bahn, for a settlement amount of 50 million euros. And that is quite a substantial, exactly, quite a substantial amount by German standards. There are two legislative developments I wanted to mention. The first is that the 8th Amendment Bill to the German Competition Act, the Act Against Restraints of Competition, has now finally been adopted. And we will speak a little bit more about that at the end of this presentation. But in this context, I wanted to say that its impact on the private enforcement arena is not very significant. So the main change is that associations of consumers as well as industry associations have now been granted additional rights to bring certain types of actions against companies that infringe the competition law. So, for example, the right to bring cease and desist orders, but they have not been granted the right to bring actions for damages. So we need to see what role these associations will play in private enforcement in Germany in the future. And the second noteworthy point with regard to this 8th Amendment Bill is that it remains silent on the question whether private plaintiffs can have access to leniency documents. And very briefly, what is the issue there? The cartel members that apply for leniency submit corporate statements and other types of evidence to the FCO or to the European Commission, for example. And these documents contain a roadmap, typically, about how the cartel functioned and what happened on specific dates and who met with whom and what they agreed and so on. So this is quite significant information that typically would help private plaintiffs to argue their case for damages in court. And so they have an interest to get access to the leniency documents. On the other hand, the competition law authorities don't have a great interest in plaintiffs gaining access to these leniency documents. Why? They fear that this will make the leniency program less attractive to companies, because it's sort of, when you ask for leniency, you also help the plaintiffs in the same way to sue you for damages, and so that becomes less attractive. So there are these sort of competing interests, if you want to call it that way. There is a European-wide discussion on the issue. There have already been two very important judgments of the European Court of Justice. It's a discussion which is also associated with the buzzword of Fleiderer, which is the name of one of these two European cases. And so the German Parliament has considered the issue, but has decided not to introduce a specific rule.
In Germany, everything is clear.
In Germany, everything might be clear. Let's see how clear it is in practice in the years ahead. So the second, that actually brings us to the second aspect, legislative aspect, I briefly wanted to mention, which is the legislative package that the European Commission has put out last month. And that includes two main measures. The first is a proposal for a directive which applies to private actions for damages in the case of competition law infringements. And the second is a non-binding recommendation from the Commission addressed to the Member States, where the Commission urges the Member States to introduce mechanisms that would allow plaintiffs to bring actions together. It's what the Commission calls collective redress, in order to differentiate it from the US-style class actions, because it's something that the European Commission wants to stay away from, but at the same time it wants to strengthen the possibility for plaintiffs to bring actions together. So we don't have time here to go into details. In the materials that each of you on the phone should have received ahead of this call, you will find a short paper on this legislative package, which you can read if you are interested. If you haven't received it before this call, you will receive it afterwards. I just would emphasize here that these measures are not yet in force. So the proposed directive still has to go through the legislative procedure in the European Parliament and the Council, and the recommendation is non-binding to start with, and in any event the Commission gives the Member States at least 2 years to introduce these collective redress mechanisms. And with that, we get again to a more scary part.
Oh. Well, yes. No, actually, it is a bit scary. Let me take that back. It's scary for me, on one hand, looking at the Federal Cartel Office, but also, frankly, looking at companies. If we look at the first bit, why I'm scared by the Federal Cartel Office, it's a question of interpretation of what constitutes an illegal information exchange. Here, in this particular case, where the Federal Cartel Office came to a conclusion, and then the higher regional court in Düsseldorf confirmed these conclusions about the information exchange, you had a situation where competitors in the motor sector met in regular meetings, and they also met with customers and various people in the industry, and they just confirmed and informed the others of the fact that they had introduced setup fees for dry mortar silos. Now, these had been, the decisions had been made independently by each of the participants in the meeting, and they had already been introduced and they had been communicated to the customers. And since they had been communicated to the customers, the other competitors knew about it too, so that it wasn't exactly like this was hugely secret information at the point where the information was given out. Only one of the mortar producers had not yet made the decision internally, but they had been contemplating it, and so they did it afterwards. What's interesting is that these are not really information exchanges about future prices or quantities, which is what we would expect under EU law to constitute an illicit information exchange, because again, these were actual prices or actual decisions taken, and everybody knew about them anyhow. Nevertheless, the Federal Cartel Office said that these communications did reduce uncertainty about rivals' future competitive behavior, because after all, yes, even if there had been rumors about it, it wasn't really certain, and the one who hadn't taken the decision yet could be really certain that the others would stick to that decision. And so it was clear that they all hung together. The other interesting thing about this is, although not new, but it's a confirmation that if you find yourself in a meeting where this type of information is being exchanged, the only way to get out of it is to declare immediately that you wish to have no such information. You protest, get it into the notes, and leave the meeting. Voila. So that was the scary part when it comes to the Federal Cartel Office. The next few the next few slides here, they are just finding decisions by the Federal Cartel Office. In most cases, we have a confectionery, we have consumer goods, and we have detergents. In most cases, several other companies had already been fined previously because they entered into settlement agreements. So one takeaway of this is it may take an awfully long time if you do not settle until you get a fining decision. On the other hand, you will be fined eventually. So that's one takeaway. But the scary one for me is that in several of these cases, the discussions took place in a trade association. Now, participation in trade association is something we constantly get questions about. Most trade associations are utterly sophisticated and read like a prayer every time they meet, a lengthy explanation that saying that they're aware of the competition laws and that nothing competitively sensitive can be exchanged and so on. And yet, not too long ago, you had pretty significant trade associations that were used by the participants and the members to exchange information, that, for example, information on dealings with customers and the negotiations and the rebates they wanted, but also to fix prices directly. And I must say, I was a bit surprised at that at this point. I thought there were other means by now. So, voila. And now I hand over to Axel again to hear more about our new law.
Right. Thank you very much. Yeah, so the promised short summary of the 8th Amendment Bill to the German Competition Act, we wanted to bring it towards the end of this presentation because we think most of you already know about it, because it has been under discussion in the Parliament for more than a year. Yeah. And in fact, we have covered the content at quite some detail in one of our previous webinars. So those of you who participated then will remember most of this. You will also again find a paper on it in the material we have sent to you or will still send to you. So if you want to know more, please look at that paper. So the 8th Amendment Bill to the German Competition Act has finally come into effect earlier this month, so it applies now, and it includes a few areas of change. In the area of merger control, the main change is the introduction of the so-called SIEC test in substantive merger assessment. So the Federal Cartel Office, when assessing a merger, will in the future ask whether the merger will lead to a significant impediment to effective competition. Now, obviously, that's the test that also applies under the EU merger regulation and that many member states have also introduced in the last couple of years. The test replaces the former dominance test. So you mentioned, Annette, when you talked about the merger decisions, the question whether the merger creates or strengthens the dominant position. That is no longer the test, although, as the European merger regulation did, this dominance test will remain as the main example in the law of how an SIEC can be brought about. And so, without a surprise, the Federal Cartel Office does not expect that this change of the substantive test will, in fact, significantly change the way it assesses mergers in a specific case. The second change is the rebuttable presumption that is included in the German law for single firm dominance. As you know, there is this clause which says, or which used to say, if a firm has a market share of 33% or more, it is presumed to be dominant, although that presumption can't be rebutted, and in fact it often was. And so the legislator and also the Federal Cartel Office said the threshold of 33% is really too low, it doesn't reflect the reality of our assessment anymore. Let's increase it to 40%, so that is what has happened now. And finally, and importantly, when each of you on the phone have looked at the question whether a specific transaction has to be notified in Germany, you will routinely have looked at one of the filing exemptions which said that even though the filing thresholds were met, there is no requirement to file if the transaction meets the conditions of the so-called de minimis market exemption. And these conditions were that the total market size in Germany must not exceed 15 million euros, 1.5, and the market must have been in existence for at least 5 years, so it cannot be an entirely new market. So this filing exemption has disappeared, so mergers that fulfill the requirement of the exemption have to be notified in the future. However, the Federal Cartel Office cannot prohibit them. So the on substance, you will get a clearance even if the transaction leads to a significant impediment to a significant impediment of effective competition, on the de minimis market. So you have to notify, but you will get clearance.
Well, except if you were too creative in how you define the de minimis market. I'm just saying that because, of course, a lot of creativity went into finding de minimis markets.
Exactly, and that was indeed one of the reasons why the Federal Cartel Office wanted to take control of that question and not leave it to the companies to determine whether they can simply not file because the merger only affects the de minimis market. There's one important area where the German law has not changed, and that concerns the types of corporate transactions that will have to be notified to the Federal Cartel Office if the filing thresholds are met. So it's the famous definition of what a concentration is, and most of you on the phone will know that Germany has a very broad definition because it also includes minority shareholdings. You mentioned, Annette, the case of the competitively significant influence. But the German law also, for example, covers non-full function joint ventures, so partial function joint ventures have to be notified as well. And incidentally, the European Commission is now also looking at whether it should introduce merger control for minority shareholdings that do not confer joint control. There's one other important aspect I wanted to cover, and that concerns the successor liability for cartel fines, because that was a hot topic of discussion before the new law now came into force. And the issue is the following. Under German law, the fine can generally only be imposed on the corporate entity which was actively involved in the cartel. So unlike under the EU rules, it's not possible to sort of automatically impose the fine on the parent entity or to hold the parent entity liable for the fine imposed on the subsidiary. And so at the same time, it was possible under the German rules to dissolve this corporate entity which was involved in the cartel before the fine was actually imposed, with the consequence that as there was no longer a corporate entity around which was involved in the cartel, the fine could no longer be imposed, even though the corporate group retained the business that actually was involved in the cartel, but simply in a different legal entity.
Brilliant way to cheat.
Indeed. And there were some exceptions to this, but we don't have to go into them now. The Federal Cartel Office was outraged about this clear deficiency in the German law, and so a remedy has been found now. There is now a specific provision which introduces the possibility for the FCO and the courts to impose the fine on the legal successor that succeeded the specific legal entity that has ceased to exist, in situations, for example, where the entity that was involved in the cartel is merged with and into the other subsidiary of the corporate group. So there are fewer possibilities now to avoid a fine in this way. I should add, however, that this rule of successor liability does not apply in the situation of asset sales. So let's see, that it might be possible to still cheat, but let's see. Finally, in the area of abuse of dominance, there is no major change. Those who look at the law will see that the provisions have been rephrased and renumbered. As I mentioned earlier, the rebuttable presumption for single firm dominance has been increased from 33% to 40%. And I would just also mention that, as many of you know, Germany used to have specific rules against a unilateral behavior, which essentially mirrored the abuse of dominance rules, but applied to companies which did not reach the level of dominance. So in that respect, the German law is stricter than the EU law, which only applies to dominant companies in Article 102. And these rules stay the same, essentially. So they are still around, so companies even below a level of dominance might still have to respect these provisions. And then, yes, the final point indeed, should you be involved in specific industry sectors such as health insurance, the press, or public utilities, you will find that the 8th Amendment Bill brings about quite significant changes in these areas, which are certainly relevant for companies involved in these industries. And with that, we are slowly reaching the end of our presentation. We wanted to leave you with an outlook of major pending cases, which you can look at more detail after the seminar, or alternatively, you can come back to our next webinar, which will likely be held in January, and where we will likely have decisions or developments with regard to the issues listed on the slides, and which we will certainly report on when they are final and relevant.
As Axel says, stay tuned and come back in January. Thank you very much and have a good day.
Thank you
Thank
very
you.
much. Bye-bye.
Good day, ladies and gentlemen, and welcome to the German Competition Law Update conference call. I would like to introduce Stephanie Biermans, Axel Gudermuth, and Annette Schild. Ms. Schild, please proceed.
Thank you very much, operator. And good afternoon, ladies and gentlemen, and welcome to the Arnold Porter Update Seminar on German competition law during the last 6 months. I'm here with two of my senior colleagues from the German competition team here in Brussels, Stephanie Biermans and Axel Gudermuth, and we hope we'll have some interesting things to tell you today. Before we get to that though, I do have just a few housekeeping matters to tell you about. One is if you'd like to see us a little bit bigger and also not see the black box on the screen, you can do that. You can move around the picture wherever you want on the screen, and you can minimize the black box that you see on the right side, I think, of the picture. Second one, we really welcome questions, so please don't hesitate. The way to do that is to click on the tab at the top of your screen, which will show you a chat function, and you can type in your questions at any time. We have somebody here to take notes and hand them over to us, and we'll try to answer them right away. If that doesn't work, we'll get back to you later. Then the last housekeeping is, yes, you can get CLE credit for this. I am not 100% sure how it works. I think you will have to tell us that you need the credit, and then we will have to send you a few. These veto rights correspond largely to what a 25% shareholder would have under the law, under the Stock Corporation Act in Germany. But we thought it would be interesting to look a little bit more at the issue of the competitively significant influence, because first of all, the EU is looking at introducing merger control for minority shareholdings, and they all say that Germany is a brilliant model. Of course, as an EU lawyer, you know that the German process is so much faster and more efficient than the EU process, that you sort of think, well, please, not in the EU. Nevertheless, it is interesting. I think it is also interesting to look at some statistics, because while these cases in Germany that are notified under the rules of acquisition of competitively significant influence are really very few and far between, less than 1% of all notifications in Germany every year, they tend to be the more problematic ones. I think on average, you have less than 0.5% prohibitions, and you have more than 10% in the case of these, or interventions in the case of these cases. Now, what is a competitively significant influence? Actually, the Asklepios Ruin case is the model case, the textbook case, because the general thing that's said covers the acquisition of an interest if the acquirer obtains rights that are equivalent to those of the shareholder in a German stock. Really difficult questions that you would need to answer to show that you really listen to this, and then you'll get the credit. I really don't think it should be an issue. So I guess, yeah.
And Annette, you rightly said good afternoon. I think we can also add good morning and good evening, because we again have a great audience for this webinar from all over the world. We have participants on the line from the US, from Europe, and from Asia. So to everyone, it's a great pleasure for us to be able to speak to you today for the next hour.
Welcome. So here's our agenda for today. Annette will kick it off with a short report on interesting merger decisions over the last 6 months. Then I will tell you a little bit about cartel enforcement and fines, followed by Axel, who will shed some light on private enforcement activities in Germany, and also what's in the legislative pipeline regarding private enforcement. Then I believe Annette will scare us a little bit in the cartel enforcement part when we learn about the new or broader interpretation of illicit information exchange. Somewhat less scary are the recent amendments to the German Competition Act, which entered into force this month, and the outlook on major pending cases with which Axel will conclude this session.
Thank you, Stephanie. Mergers. Well, there's a long list of topics. It probably looks a bit scary, but I think it's actually quite interesting what's happened over the last 6 months. Not necessarily because there was anything revolutionary, but because each of the cases that we're looking at really helped shed light on some of the concepts of German competition law and how to go about notifying mergers and looking at various elements of the analysis. So I think it's actually a quite interesting half year in that respect. First one, let's look at that. Domestic turnover. That's obviously a very important question. On the one hand, whether you actually get over the thresholds, because you do need to have a certain turnover in Germany, as you all know, or whether you come into the de minimis sphere. It is always a question how you attribute turnover. And you may have followed this before. There was, a while ago, there was a decision by the Federal Cartel Office that looked at how you attribute turnover in a situation where the contract is made outside of Germany. It's a multinational company. In this case, it was in Switzerland, that made that central purchasing decisions, concluded a contract centrally, but then had the goods delivered in various countries, including in Germany. Federal Cartel Office said, well, the specific performance of the contract is the delivery. That is in Germany, so clearly we look at the German turnover. And that is what was now confirmed by the higher regional court in Düsseldorf. What I find interesting, because we have the question not only in Germany but also in the EU, the Federal Cartel Office is 100% convinced that this is fully in line with what the EU is doing in the jurisdictional notice. And if you look at part of the notice, I think they're entirely right, because they also talk about the place where the specific performance takes place. On the other hand, there's also something about multinationals, and I'm not 100% sure that the EU would come always to the same conclusion as the Federal Cartel Office. But that is there to see. The next decision is interesting. That is a clearance decision. And that's interesting, I thought, if you look at the concept of competitively significant influence. Because here we had a situation where the purchaser wanted to buy 10.1% in another company. And not only did the Federal Cartel Office say, yes, we have jurisdiction to review that, but they also found so many problems that the buyer had to give commitments to sell several hospitals in an area where the Federal Cartel Office thought they were dominant. Question is, of course, always, if I buy such a small stake, well, why do I really need to notify, or when do I really need to notify that, and when is there really an issue? In this particular case, the situation was quite specific because the articles of association of the target gave reasonably significant veto rights starting at 10%, and they're still fighting about that. And these